The most important thing here is that most health professionals have a professional license that have obligations, right? And there's certain things you can and cannot do. Nobody wants to threaten their livelihood for a short-term brand deal, right?
Hello, and welcome to the Master the Media podcast. I'm your host, Amy Gorin, and I'm here today with a very special guest. I have Dan Ilkay, who is an attorney and an instructor, the legal instructor for Master the Media. Welcome, Dan.
Thank you, Amy. Appreciate the invitation to your podcast.
It's so great to have you here. And today, Dan and I are going to be having a conversation that I know a lot of you are going to be excited about, which is how, as a healthcare professional, you can protect yourself legally. So, we're going to be talking about all the things, including contracts and, terms that you should put on your website and contracts that you should have with brands, to have those protections in place. So, kind of like, I don't know if we can say that this is I mean Dan probably thinks it's fun, so I'll just say it's fun back end stuff. So Dan is an attorney with 20 plus years of experience. He's worked with AMI, a General Electric company, Reef Technology, Perfect Picnic, whole bunch of other awesome places. And his firm, ILKAY Law, specializes in business and corporate law, contracts and agreements, and intellectual property. And Dan is the legal instructor for Master the Media. Welcome, Dan. Do you want to tell us a little bit more about yourself?
Sure. My practice specializes in business, corporate law, and contracts. And as you're aware, I've assisted the Master of the Media group on understanding contracts, why they're important, and understanding really the terms that are spelled out in these contracts and how they impact their consultancy, and really trying to help people grow their practice. It's an important aspect of what they do is really paying attention to these details.
Oh, I love it. And I think now that you've, worked with a lot of the dietitians and doctors and other healthcare professionals in Master the Media, I think it's fair to say you have a specialization, or at least one of your specializations is in working with healthcare practitioners.
Yeah, I really enjoy helping this community. I know that in looking at these things, it can oftentimes be complex, be a little confusing, and so my job is to really break these terms down into simple, understandable, and relatable practices, and I hope to talk about that with you today.
Yeah, for sure. So, I mean, gosh, I have so many questions for you, but I think, let's start with when, we're talking specifically to healthcare professionals who want to work with brands and, be their spokesperson or create blog content or create social media content for them. What protections should you have in place when you're doing this type of work?
Well, I mean, the first most important thing that I think gets overlooked is really reviewing the contract, really uh, sitting down in a quiet room and reading line by line what's spelled out. Many of these contracts, these are drafted by the brand's attorneys. And so, as you would expect, the brand's attorneys are drafting these in their favor. The most important thing is that I think a lot of professionals don't understand. It's good to question certain terms. It's good to push back. It's good to negotiate. I think it increases the respect that you receive and that you really pay attention to the items that are drafted within the contract. And if there's something that doesn't make sense, ask somebody. You know, Amy and I drafted a template contract, and so that's a good starting point, I think, for starting those discussions, maybe comparing the contract you received against this template contract, and just try to understand the most basic terms. Really, oftentimes what I see is a exclusivity term, and so understanding what that means in terms of your ability to work with others. Perhaps you specialize in a certain area, and maybe it makes sense for you to work with a legacy large brand, but if that's going to block you from working with others, you may want to think about that and think through where you are in your practice and what you specialize in, and make sure that makes sense for you.
Yeah, so let's I just want to clarify for anyone who's like what contract are we talking about? So Dan actually helped create a really comprehensive contract that has terms that you can, add in or delete based off of what your partnership is with a brand. So if you're doing, anything from recipes to blog posts to social media to, so many different things. And we always, in Master the Media, because Dan's one of our instructors, we always advise, if you can provide the brand with a contract that you created, so the one in Master the Media, then you're in a much better place because you don't have to do all the work to get that contract that the brand gave you to the place, right?
Sure. Yeah, so that's part of my message today is everything's negotiable, right? You're negotiating your compensation, you're negotiating the scope of services that you're providing, and it's important to just really understand what you're committing to. Some of the things that I would encourage some of the listeners to pay attention to is automatic renewal or evergreen contracts. How long are you offering your name, image, and likeness for use by these brands? And do you have the ability to control some of the messaging before it gets released, ensure that you have some editorial privileges to make sure that your name is not being used to endorse certain things that you may not agree with, or perhaps could even be problematic for your licensure. So those are important things just to think about and to consider.
So I
Uh,
think pause there because I think when what I'm hearing is because you can think that you're agreeing to, okay, the brand is going to use my name and likeness for social media. And what the contract might say is that they can use it for, a commercial on TV. And that's kind of what we're saying we need to really read the contract and make edits, right?
Certainly, it's best to define the scope of how they use your name, image, and likeness, in terms of how they're going to apply it, what products they are attaching to your name, and then also consider the time scale. What's the time frame? I've seen plenty of contracts that can give you some specific scenarios where folks are granting perpetual rights, so rights that never end to use their name, image, and likeness. And this is something you probably do not want to do. You're probably leaving some money on the table, and this could impact the future of how practice your consultancy.
Yeah, I mean that we've had a lot of Master of the Media students come to us and say, "Oh gosh, like I've already, in the past signed away rights for, this probiotic for perpetual use." And that's not good because that means that a future probiotic in this case might say, "Well, we can't work with you because this other brand's still using your name and likeness years later."
Yeah, I mean, ideally, it's best when you receive this contract, spend some time reviewing it yourself. It always helps to have a second set of eyes look at these contracts, talk to your colleagues, and really understand what you're committing to. Because once you sign a contract, it's too late, as they say in the legal world. It's you can't unring the bell. Once you sign a contract, you're committed. It is legally binding. And we'll talk a little bit more, I think, throughout this conversation on some of the areas you should pay attention to and
Yeah.
what really matters long term.
Yeah, for sure. So let's talk a little bit about like, okay, so you have that contract in hand and you said you should sit down and read it. What does that look like? Should you sit at your computer and, do you track changes? Should you sit with a printed copy and use a red pen? Like, what should you be doing?
I'll give you some of the secrets that I do because even as a lawyer, contract language can be quite dry. In some ways, I think contract language is computer code. It's really providing sort of the guardrails for a relationship. Um, you enter a contract with a company or a person, uh, really to address what ifs, right? You don't sign a contract. If everything goes right, you really don't need a contract, but rarely that's the case. And when it comes to two humans having a conversation, sometimes two folks could have different interpretations of that conversation. Putting it on paper helps. And what I like to do is read it. You can also sometimes you can plug this into your computer and have it read to you. That sometimes helps when you have it in front of you. Um, and um, and then just go ahead and highlight certain areas that maybe you don't understand. and then talk to some folks. And, with all the with all the resources available online and the like, you can perhaps understand a little bit better what you're committing to. And then just understand where you are in your career and where do you want to go. Maybe it's okay for you to sign an exclusivity clause. Maybe it makes sense, or maybe it doesn't. So it's going to be very specific to your situation, where you want to go, what are your objectives long term, and just make sure you don't paint yourself in a corner so that you're prevented from working with others. That what you'll find is as you increasingly work with brands, you'll become more and more an expert and a resource. And so other brands will be attracted to you. And so just make sure that what you're doing will allow you to continue in that growth trajectory.
So say that you had a conversation with a brand that did not include exclusivity. So you said, okay, this is, say, a $10,000 partnership. You get the contract and it has exclusivity for this giant category. It's not just probiotics. Let's say it's all supplements for 12 months. What would you suggest that that person do?
Well, the best thing is to have a conversation, much like we're having in person or through a video conference, and really help your client understand where you are and why certain things may or may not be possible. You could encounter also issues with your licensure, um, depending on the state that you're licensed in. There may be certain things you can and cannot do. You need to understand that, and then you just need to understand what what those restrictions are. The best exclusivity clause is the one that's laser focused to the concerns of your client. If it's an overly broad exclusivity clause, it's problematic because you're going to need to charge more because you're really preventing yourself from working with others. When you're a consultant in this situation, you're trying to provide value to as many different brands as possible. So if you're going to agree not to work with others, it needs to make sense and it needs to be well understood. The best time to do that is when you're negotiating the contract. Once you sign it, if there's any ambiguity, it could be a recipe for conflict, which is really not the situation anybody wants to get into. You don't want to misinterpret, even if you think you understand it and later find out that perhaps you signed an exclusivity, you can't recommend other products. And maybe you find that out after the fact, and that could be a violation or a breach of the contract. You want to avoid that. And so the best way to get there with your client is have a conversation. And that conversation will explain why certain things are possible and why things may not make sense and why it's in everyone's interest to define what is considered inside and outside the exclusivity terms.
Yeah, I think that that's really good advice. So like the what I've done in the past, and you can tell me what you think, because I think our listeners are, interested, is say with that $10,000 contract, the brand, wants exclusivity for all supplements. And I might say, well, that's not possible because that limits my work too broadly. Like supplements are probably like one of the most lucrative fields for a dietitian working with brands. But what I could do is give you exclusivity for probiotics, but that would be $1,000 a month. So if that's not within your budget to increase this contract by $12,000, let's talk about how you'd like to move forward. Like, would that be a good way to have that conversation? Or is that, would you tell me to do something different?
I like that angle. One of the things that I share with a lot of the students is that in contract negotiations, it's best to never say no. It's best to say price accordingly, right? So if you want a overly broad exclusivity or non-compete clause, you're going to charge accordingly, and that will help guide your client to correct thinking and perhaps understand why that may not make sense. And together with your client, you can tailor the non-compete or the exclusivity appropriately in a way that makes sense so you can price this and grow the relationship.
I like that. So it's basically like you're approaching the conversation with respect. You're not jumping on a defensive. You're just assuming that they didn't know that this was asking a lot.
Yeah, and as you're aware, you tend to specialize in certain areas. Maybe you specialize in plant-based foods. And as a result, that's where you're gaining most of your clients and you specialize in this area. It may not make sense. It probably does not make sense for you to exclude yourself from working with others in that space.
Yeah, I mean that's really good advice. So when should you rope in, like when should you hire an attorney and when should you try and do this on your own?
Well, it depends on where you are in your career. I know a lot of folks are uh, concerned about maybe the cost of retaining an attorney. There are attorneys out there that specialize in this and that they can provide value and just really increase your standing when you're having a conversation with these brands. I think automatically signing a contract the minute they send it to you could be misinterpreted. It's best to explain that I really appreciate you sending this over. I need a day or two to review this. And then, depending on what's written in there, if there's something that you don't understand, you can take this either to your other colleagues in the field or you can approach an attorney. I think it depends on where you are in your career. It's always best to have some, legal expertise in your corner. The best time to do that is probably before you receive the contract, just because of the timeframes it takes to retain an attorney. And then ask those questions. And I would say that that will give you the opportunity to get better at this, right? There's plenty of folks that negotiate contracts without attorneys. You just really need to understand that. And the more practice you have at, the better you get.
Yeah, I mean, I know like my first few times working with brands, I hired an attorney and like even now when I get like a 17-page contract, I might be kind of like, you know what, I don't even know if it makes sense for me to spend 5 hours reviewing this when someone who is really specialized this can review it more quickly than that.
Exactly. And perhaps you can be more efficient, right? I mean, you're good at what you do, but there are specialists that are great at reviewing contracts. And so I say that taking a look at the most important terms again are some of the things we're talking about: exclusivity, name, image, and likeness. Also, pay attention perhaps to the governing law, the venue. Oftentimes, the brands will pick their home state or their home venue. Maybe you're thousands of miles away, so that may not make sense. And then just pay attention to confidentiality and other uh, non-disparagement type clauses. Those are the type of things that come up oftentimes in these things. And if you have questions, you can come back to the brand too, right? Maybe you could just say, "This is unclear to me. The way this is drafted, this doesn't make sense. Can we work together to improve this language?" Right?
I like that.
And and everyone understands that it's very important that they review these contracts and understand really what's stated there.
Yeah, so I think let's dive a little bit deeper into some of the terms that you brought up. So you mentioned name and likeness, and I also wanted to talk about some of the kind of like you said professional licensure situation. So let's jump a little bit more into those. Yeah, for name and likeness, I mean, what should you be watching out for in the contract?
Well, I would say that you really understand the two most important aspects of this is what are you giving to the brand? Okay. How can they use this? What posts are they going to be providing this attached to your name, image, and likeness? What platforms perhaps are they using? You have the ability to negotiate that. And what's the time frame? In the master media course, we take a look at the active term of the contract and the tail end of the contract. So you'll have an active period of the contract. So you want to pay attention to where are you granting those rights, and really some of the best ways to handle this is to have a last look before they post things, right? So you can say, hey, this is within what we agreed to in the contract, but this seems to be outside. Let's have a conversation, right? And so
Yeah, I
that
like
gives you a
that.
chance to look at that. There's some new issues, of course, coming up, as everyone's aware, with name, image, and likeness when it relates to AI and personas and things like that. So again, I wouldn't be surprised if you start seeing this in contracts. And so This is an emerging area of the law, but it's handled fairly similarly to how
Yeah.
any social media or electronic post is handled.
I mean, is there a clause that you need to add to the contract to protect yourself from, them creating an AI version of you?
It's possible. You see this now more than ever. Again, you can define that in the contract, and I would just say pay attention to it. I know that in other areas, in other similar health professional areas, this is becoming more of an issue, right? So.
Yeah, it's like crazy the stuff that you have to think about these days.
And,
Um,
and I would say in having that conversation, you'll understand pretty quickly whether they're going to be a good partner or not. What I've found is that in contract negotiations in general is very rare, but it is possible, and I've seen this where the contracts take it or leave it, right? And if it is take it or leave it, you may want to ask yourself, is this somebody you want to work with, right? And if they are being very difficult during the contract negotiation phase and not really understanding where you're coming from or pushing you to do things that may be beyond the professional obligations you have for your license, it's a good time to question that before you sign the contract, right? The
yeah.
most important thing here is that most health professionals have a professional license that have obligations, right? And there's certain things you can and cannot do. Nobody wants to threaten their livelihood for a short-term brand deal, right? So,
Yeah.
think
Can you
about
give
that.
some examples of things that might be red flags regarding licensure?
Sure. Well, we can get into some of the FTC type rules. So, if you're endorsing in social media, there's certain disclosures that are required. Um, the standard is clear and conspicuous. So you really need to be upfront with your audience on what you're sharing. And I would say that where I've seen the issues most often is certain supplements that are making claims that are overly broad related to health outcomes. And when I've helped other dietitians in this area, the brands were very resistant to change or authorizing the dietitian to approve posts. And in those instances, there was questionable claims being made. And so it's very important that you pay attention to that. Make sure you understand your obligations related to FDA claims, curing diseases and handling certain health ailments, and make sure you really understand that before you commit or words are put in your mouth, right? And so,
Yeah, I mean, I think you brought up a few really interesting points. I mean, so let's break them apart a little bit. So for the FTC disclosures, that's just something where if you're scrolling on social media and you see hashtag ad before a post, like that's what we're talking about, and then saying, this I'm partnering with X brand. I have actually, it's interesting you bring this up because I've actually had brands where I've added that into the contract. I'm going to disclose, and it's more for, say, I'm doing a media interview and I'm disclosing to the media outlet. And they wanted to, and some of these brands have wanted to take that out. And to your point about, is this going to be a good partner? And that's a definite no. This is not going to be a good partner if they don't want me to follow the, legal way of doing this.
yeah, it's important to remember too, as a health professional, you're considered an expert under these regulations, and so you have a higher standard than, say, a typical influencer, since you have a credential attached to your name, and that credential adds value and respect to what you're stating. So just really tune into that. Anytime you're receiving gifted product, any sort of compensation, anything related to that endorsement, these FTC rules apply.
Yeah. And I mean I think that's super important. And it's also, we're not just talking about social media. It's like if you're going on TV on behalf of a brand, you have to disclose, here I'm partnering with X brand to talk about, whatever. And obviously you would have disclosed that to the TV station ahead of time. One thing I think would be interesting to touch on. So you mentioned FDA regulations and supplements, which is something I've come up, I've worked with a lot of supplement companies, and most of the time, like you have the little if they're doing things by the book, they'll have the little asterisk about, the FDA regulations, like at the end of a blog post. And I've had it where, there's a lot more back and forth than there are with some other brands where, everything I write, it gets reviewed by the supplements legal team. And that's kind of like the green flag for me of, okay, this brand is really super by the book. They have their own legal team to make sure they're in accordance of all the regulations. And I guess to your point, it's a red flag if they're just like it's the wild, wild west, right? Because it's not the wild, wild west with it shouldn't be with supplements.
Yeah, I mean, your license is at stake here. It's not their license. And so they're approaching you for that endorsement. What I would suggest is that you just don't parrot the claims that are being made by the brand. Evaluate the product yourself and really think through, is this a product I want to endorse, right? You're attaching your personal brand to their brand, right? And so if there's certain claims being made that are outside of the compliance of these rules, it could be problematic. You could be held personally liable. And so anytime that you're endorsing a product that claims to, endorse, treat, or cure any sort of disease, just tune into that because supplements, as everyone's aware, they're not approved by the FDA, and so, but they are paying attention to really what claims are being made associated with those products. And so I would say just really scrutinize that carefully before you attach your name to it.
That makes sense. What about, indemnification and those types of protections? Because a lot of the contracts I receive from brands, it's one-sided, where there's protection for the brand, but not for me. So how, what are your thoughts on that and how should we be approaching that?
Well, indemnification, if anything goes wrong, you want mutual indemnification. So you want to be protected if there's a claim from third party, from a user or, of the product, that you're not held responsible, personally responsible, or your company for that matter. Um, and so, especially since you're not in complete control of these brands, you're providing marketing support for them, but you really want to be tuned in. Mutual indemnification makes a lot of sense. Also, I would encourage our listeners to consider having a limitation of liability in every contract. The starting point for that would be capping liability at the contract amount, right? So that you are not going to be subject to multiples. I mean, unless you have a cap on liability, you potentially could have unlimited liability, right? And that's another reason that you should not be personally contracting with these companies. I would encourage users to form their own entity, an LLC, in their home state. And that is really the best way to approach these brands. It also raises your profile. It shows that you're a professional and that you take your practice seriously. So,
Yeah. So like in the beginning part of the contract, it would be like instead of, this contract is with Amy Gorn, it would say, the name of my LLC instead of my actual name. That's what we're talking
yeah,
about, right?
yeah, you don't want to be you know, a person contracting. It's preferable that you're not. If you also run, say you're a registered dietitian and you run a practice, you may also, depending on how many brand deals you're getting, you may want to also consider separating that and creating another LLC for the brand deals, just for, keeping those two liability pools separate. It makes a lot of sense to do that. But that depends on how much activity you have.
So
And
yeah, can we actually dive a little bit deeper into that? So what I think I hear you saying is when it's you, not your entity, the brain, whoever wants to sue you can go after your personal assets. So that's why we want the entity. But then if you have your brand practice and say you have a huge private practice, you want to separate those because you have, maybe you have a business owner with your practice and you don't want to rope them into the liability. Is that kind of what we're talking about?
yeah, so when you don't when you're contracting as a sole proprietor, all your personal assets are exposed, okay? So your bank account, your home, your car, whatever other assets you own are fair game to go after, okay? And from a legal protection standpoint, it's best to create a barrier between your business and your personal life, right? Because and that's really the purpose of legal entities. They're designed to reduce your exposure and allow you to contract and provide services to others. You could be a single member LLC, which is what a lot of folks create, but you're keeping your business and personal finances separate. You're not commingling them, and that will ensure that you have full protection.
That's a really good point to consider. What else should we be looking out for in the contract?
Well, take a look at the confidentiality elements there and ensure that you understand what they're going to be sharing, because oftentimes you have you're prevented from sharing information with others. Make sure that in many cases, um, the brands that you're working with will have additional clauses related to non-disparagement and the like. And so you want to make sure that you're allowed to legally explain to others what the pros and cons are of the product. And I would also say that sometimes they have clauses I've seen in contracts where there's a morality clause so that it's sort of an excuse for them to terminate the contract. They feel that your behavior or what you're projecting in social media doesn't align with their image, so they can terminate. So really defining what that means. And then probably the most important is what is the automatic renewal language in the contract, okay? Because I discourage folks from signing evergreen contracts that mean they perpetually renew. There may be some reasons why you want to do that, but there should be the best way to start the relationship is start for a year or two, and then you can have an opportunity to renegotiate and perhaps change some of the terms in the contract. When you have auto renewal, the contract just continually rolls over, and you could be locked in, right? And especially with some of the confidentiality NDA provisions, they continually there's a term associated with that. So a lot of times I just saw an NDA today where the last time they share information with you that's considered confidential, that the contract lasts for another 5 years after that point.
Oh, geez.
So they can continually share information with you, and it extends the term of the NDA. It's best to have a defined period in there so that everybody understands when this starts and when it ends. And so
Yeah.
um,
Actually, yeah.
those are some of the important things that I would pay attention to. You know, I have helped a number of dietitians, and I've seen where oftentimes they approach me after they signed a contract. In this case, it was with a supplement brand. And what they didn't see inside the contract was this exclusivity provision was for 2 years. Now, they were just getting started. And after year one, they were approached by a much bigger company, really their dream brand, if you will, and offering many multiples. But what this forced was that they had to retain an attorney to negotiate a release, right? And there was a cost associated with that, right? So the best time to really pay attention to all of these clauses and all these issues is before you sign, right?
Yeah.
After you sign it becomes more time consuming, more of a distraction, and perhaps more of a cost. And so just take a look at that and make sure you understand what you're signing before you sign it.
Yeah. And that also doesn't, by like you're gonna probably destroy your relationship with that original brand if you have to hire an attorney to release you from a contract.
Yeah, it changes the dynamic. The other point that we brought up earlier on that I'd like to emphasize too, I encourage folks to have a content approval. So before any content goes live, especially if it involves your name, that you get final sign off, right? And so that's sort of a way to gatekeep some of the information that's being shared with the world before it gets released. And so this is I think a relatively benign way to have approval before things get posted.
I like that. Um, have you ever had someone have to, like what, say you have that approval in place and, something gets published without you approving it and you don't like it, what would be the legal step to handle that?
Well, I would push folks again to have another conversation and explain why this is important to you. Perhaps they need to understand that you work with other brands and you want to make sure that there isn't any overlap in commitments, that your primary objective is to comply with the contract. And so this is a way to ensure that we continue to work together and support each other. So.
Definitely. As for timeline, because I know a lot of times when, especially my Master of the Media students, it's like everything feels like it should be rush, rush, rush. When you're talking with a brand, like, oh, I need to get back to them as soon as possible to make sure I get this partnership. But then things have to slow down, right? When it comes to the legal part, because you can't, I mean, like what's the appropriate amount of time to spend like reviewing a contract and going back and forth with the brand on the legal stuff?
Well, I mean, oftentimes there's some urgency on the brand side just because they have certain objectives. I think understanding your client's needs will help you gauge the timeframes that are needed. I don't think it's unreasonable to take a day or two to review a contract, as long as you're communicating that to the brand. Explain, hey, I just need a day or two to take a look at this. This is really important for the both of us. I may have some questions. Is it okay if I reach back to you before signing? And that just shows that you're being responsive and you're not just delaying for delaying's sake. You're really your purpose is to improve the relationship, and this contract is a good way to ensure that we're working together appropriately.
I think that's a really good point. Clear communication always goes a huge way, right?
Yeah, and the other thing to think about, you're getting compensated, right? So, I mean, you're providing services, and you want to get compensated. Pay attention to the payment terms. When are you getting paid? How are the funds being released? Is there milestone payments? Are you getting upfront money? Are you getting paid at certain amounts throughout the contract? You don't want to be chasing money. It's difficult, time consuming. Chasing payments is a huge distraction. So to the extent you can, get the money up front, right? Or get the money, at certain intervals that makes sense so you can stage your work efforts appropriately.
So like 50% upon signing and like 50% upon re get sending the deliverables to the brand. Would that be reasonable?
I mean, if you can get that, great. It may or may not be possible, especially early on in the relationship. Maybe as you grow the relationship and they understand who you are and you work well together, you could push for um, more aggressive payment milestones. But nevertheless, just stage your work efforts so that you get paid, at some interval, maybe monthly or depending on the length of the contract, you can ensure that your work efforts, you can have the ability to delay your work efforts if you're not getting paid, right? And so pay
Good point.
attention to the payment terms so that you don't finish a huge contract and you're still waiting on getting your first dollar from the brand.
That makes sense. Is there anything else you want to share with our listeners about this giant topic?
Well, let's talk a little bit about forming your company. So the best place to do that is your home state, especially wherever you're licensed. The main reason why you want a separate brand is for liability protection, but you also want to create a bank account that's separate from your personal bank account. So think about that. It's also beneficial for your social media presence to have a brand, if you will, your own brand. Maybe it's your name, but again, it has an LLC attached to it. So think about that. And then really tune into your professional obligations. So whatever your state licensure requirements are, pay attention to that because the last thing you want to do is for a nominal payment lose or harm your licensure. I mean, you work really hard to get that license, whatever that is, whether it's an MD or RD. And so it's very important. I think it also raises your profile. It shows you're a professional when you have a separate legal entity. And so the takeaway here is really build that legal wall, separation between your personal life and your business life, because it's a lot cheaper to do that up front than it is to do later. I've seen that with clients where they're doing brand deals in their personal name, they have no LLC, they have no separation, and that if you're working with certain brands, you can inherit some of the personal liability for what you're doing. That could be problematic. You want to keep your house, you want to keep your car. So
Yeah.
those are important things. Now, the chance of that happening, are unlikely, but certainly possible if you're working with a brand that's making claims that are beyond what's permissible. So think that through, and also just think about the where this we talked about when they're using your name, image, and likeness. Think about not only the scope, but the geographic scope at which they're, because um, they could be translating what you're providing in other languages and things like that. There could be European markets or Latin American markets. So understand that where in the world they are allowed to use your name, image, and likeness, right? And then what you're allowed to do with your professional licensure. Can you endorse products in another country? That's something you need to
Yeah,
you need to
that's a
understand
really
that.
good point.
Yeah.
Really good point.
And so your credentials are really important, and you just don't want to create any sort of liability or risk those licenses. So those are my main points. And I'm available if folks want to talk to me. You can find me on ilkaylaw.com. You can also find me through the Master of the Media course. I really enjoy helping folks grow their company, help them really understand and translate some of the complicated legal language in a way that makes sense for everyone and just help you draft contracts that make sense. There's really no need to have overly legalese in a contract. The best contract is the contract that everybody understands. All right. There's no benefit in having $10 words or translated Latin words. If everybody understands the contract, you're able to work together, and your objective is to provide value to these brands. And so the better the contract, the better the relationship in the long run.
I love that. Do you have any resources you want to share with our listeners?
Well, I point you back to the Master of the Media course. Take a look at be sure to take advantage of the template contract. That's a good starting point. Just like any template, it's a template, just addresses the main issues, but every circumstance is different, and your contract needs to be tailored to your particular circumstances. And then I would say also rely on your professional boards that you have licenses through and use them as a resource as well. Oftentimes they have additional information that could be useful in your practice. And so I would encourage you to take advantage of that.
Well, thanks so much. And for everyone who wants to touch base with Dan, his website is ilkaylaw.com. And I hope you reach out to him. He has helped me personally, with Master of the Media, obviously, and then I've also hired him for some of my business stuff as well. So I can vouch for him being incredibly, incredibly helpful. And for anyone listening who wants to learn more about Master the Media, we are actually hosting a free masterclass tomorrow so that's Wednesday, May 20th at 1 p.m. Eastern Time. And we're going to teach you how to land $50,000 in brand partnerships in the next 6 months. So if you want to grab a seat, go to masterthemedia.co/masterclass. If you're listening to this after May 20th, no worries. Go to that same URL and you can grab the replay. So thanks so much.
Take care. Talk to you soon, Amy. Be well.